Yes, good morning to all. Good morning to all. Today we will discuss a section from the Trademarks Act as well as one case law relating to trademarks. Now coming to section 57, that is chapter 7 of Trademarks Act 1999. Chapter 7, rectification and correction of the register. Power to cancel or vary registration and to rectify the register. Section 57, subsection 1. On application made in prescribed manner to the appellate board or to the registrar by any person aggrieved, the tribunal may make such order as it thinks fit for cancelling or varying the registration of trademark on the ground of any contravention or failure to observe a condition entered on the register in relation thereto. Subsection 2. Any person aggrieved by the absence or omission from the register or any entry or by any entry made in the register without sufficient cause or by any entry wrongfully remaining on the register by any error or defect in any entry in the register may apply in the prescribed manner to the appellate board or to the registrar, and tribunal may make such order for making, expunging or vary the entry as it may think fit. The tribunal may in any proceeding under this code decide any question that may be, scroll down. Yes. Any person aggrieved by the absence or omission from the register of any entry by any entry in the register without sufficient cause or by any entry wrongfully remaining on the register or by any error or defect in any entry in the register may apply in prescribed manner to the appellate board or to the registrar, and the tribunal may make such order for making, expunging or varying the entry as it may think fit. The tribunal may in any proceeding under this section decide any question that may be necessary or expedient to decide in connection with rectification of the register. The tribunal of his own motion may, after giving notice in prescribed manner to the parties concerned and after giving them an opportunity of being heard, make any order referred in subsection 1 or subsection 2. Any order of the appellate board rectifying the register shall direct the notice of the rectification shall be served on the register in prescribed manner, who shall upon receipt of such notice rectify the register accordingly. See, after this tribunal act, that is tribunal reforms, now this appellate board, intellectual property appellate board is now no more. It is removed. Now only this function is now performed by the High Court. Any order passed by the registrar of trademarks is now appealable before the High Court only, not before the intellectual property appellate board. And section 58, correction of registrar. So why this we are making the application for correcting the registrar or cancellation or varying? If any person, if we have registered our trademark, similarly some other person also registered a trademark and he has got obtained that trademark registration by giving misrepresentation or anything like that, the original owner, the person who is already having the trademark, may file an application for cancelling the other person's trademark who is using trademarks similar to his trademark, who is using prior to him. Okay. For this purpose, this section is given. So for section 57 and 58, normally the case for infringement or passing of the trademark, the application or petition has to be filed before, not before the district court or to the High Court. But that is not below the rank of district court under section 134 of the Trademarks Act 1999. Yes. Now coming to the correction of register. The registrar may, on application made in the prescribed manner by the registered proprietor, correct any error in the name, address or description of the registered proprietor of a trademark or any other entry relating to the trademark, enter any change in the name, address or description of the person who is registered as proprietor of trademark, cancel the entry of a trademark on the register, strike off any goods or classes of goods or services from those in respect of which trademark is registered, and may make any consequential amendment or alteration in the certification of registration, and for that purpose may require the certificate of registration to be produced to him. Come down. The registrar may, on application made in the prescribed manner by a registered user of a trademark and after notice to the registered proprietor, correct any error or enter any change in the name, address or description of the registered user. So this is section 57 and 58, which gives us an opportunity if we are wrongly registered any goods or services or any other alteration we are doing in the trademark in the registered trademark, for which now the registrar has the powers to make some alterations in the registered trademark. And if any other person using our trademark, similar to our trademark, then we can also make an application for cancellation of the trademark. Now come down. We'll go for a case law. This is an order passed by the Honorable Bombay High Court in the matter of Hyderabad Food Retail, Bajaj Supermart, that is Hyderabad, that is Bajaj Electricals Limited versus Urban Food Mart India Private Limited. The observation given by this Honorable Bombay High Court is Hyderabad Food Retail Chain, Bajaj Supermart, restrained by Bombay High Court for infringing and passing of well-known trademark Bajaj. In this case, what happened is a person who is in Hyderabad opened an brand, that is started selling a brand in the name of Bajaj Supermart. So actually, you all know that Bajaj means it is a well-known company. So if anybody purchase that product, they think that it is belongs to Bajaj company. So he started using the trademark of reputed company's trademark. So following this, what happened is the Bajaj, this company Electricals Limited, has filed an suit, that is civil suit, in the Bombay High Court for the infringement and passing of the trademark. So the brief fact of the case are that the plaintiff has been using its mark Bajaj openly, continuous and extensively since the year 1961. The plaintiff's trademark has achieved the status of well-known mark, and the same has been recorded and recognized by the trademark registry and various courts. Defendant, on the other hand, operated retail convenience stores of food retail chain in Hyderabad by the name of Bajaj Supermart. Defendant had filed trademark application for device mark or logo containing the words Bajaj Supermarket in the class 35. The same appeared to be deceptively similar to the plaintiff mark, that is Bajaj Electricals mark. Come down. So the petitioner is the Bajaj, the registered trademark of Bajaj. We can see that the Bajaj Supermart is given here. This unregistered logo or Urban Food Mart. The plaintiff in their plaint also produced material to show actual confusion which is being caused among the members of the public due to defendants' use of their mark Bajaj Supermart. In addition to this, the incorporation details of Urban Food Mart India, describing its services as dealing in all kinds of goods, materials, and items that not limited to food and provisions, household goods, groceries, consumer durables, jewelry, home improvement products, footwear, luggage, books and stationery, health and beauty products, electrical and electronic goods, computer and accessories, telecom products, agri-input projects, furnishing, automobile and accessories, financial products, and acquiring and running food, service and entertainment requires amusement parks, restaurant and food courts. And the plaintiff have proved the malafide intention of the defendant to rely on the on the goodwill and reputation of the plaintiffs, that is Bajaj Mars, and later diversify its business activities to goods and services associated with the plaintiff brand. So you know that Bajaj has Bajaj Food, Bajaj Consumer Products, Bajaj Electricals, Bajaj Finance Limited, everything they are doing. So the respondent, that is defendant, also in its main objects, he included all these services, and he has got registration of the trademark for all the purpose. So you want to expand in the other areas also, where the plaintiff is also doing the same business. So what happened is, after that, hearing these both sides, in view of the aforesaid, the defendant gave an undertaking. The High Court required them to give an undertaking that is different from the defendants, and that the defendant has given an undertaking and were restrained from using any mark which contains the word Bajaj in any manner whatsoever. The Honorable High Court granted relief to the plaintiff in terms of prayer A and B and of the plaintiff's interim application. And Bajaj, that is Bombay High Court, passed an interim order restraining the defendant from using the mark Bajaj Supermart in relation to food retail chain, thereby committing trademark infringement and passing of the plaintiff's well-known trademark Bajaj. Defendant, the white said order were directed to remove all signage, use of marks on shopping bags, cartoons, packing material, etc. within a period of 3 weeks. They are given a 3 weeks time, and their court has passed an interim order, that is injunction from using the word Bajaj for the products. So this is the case. If you have any doubt, you can ask to me. Any doubt?
No, sir.
Okay.
No problem.
Okay. Thank you.
Thank you, sir. Thank you, sir.
Thank you.